minimum. So I'm just sharing something for your consideration. But I appreciate your attentiveness today, ladies and gentlemen. Thank you, Mr. Chairman. Mr. Chairman.
Thank you very much, Mr. Attorney General. Senator Jones, any comments or questions?
Any questions? I see no questions. I have a question. Mr. Attorney General, how many juvenile lifers do we have in prison in Michigan, and were they all put there for murder?
Let me try to answer the question as best I can. And there's some 330, I believe. I think that's the approximate number, 338 teenage murderers who've been sentenced as adult, as I understand. Some 100 or so of which have been sentenced prior to 1990. And I think, there's also something to remember here. If there is some case, that might warrant an exceptional approach, then there's always the issue of clemency that could be done. But we can't take a broad brush and make a guesstimate on what might happen. That'd be wrong. Yes, sir.
Thank you, Mr. Attorney General. Recently in our country, it is alleged that two 16-year-olds beat a World War II veteran to death in a parking lot, and a 15, 16, and 17-year-old shot an Australian ball player as a thrill because they were bored.
This is the Oklahoma issue.
Yes, sir.
Yeah.
I'm very concerned that we send the wrong message if we're not tough. This is a state without the death penalty. It seems to me that we have to have tough penalties in place to send the right message. I just wondered what your opinion was.
Well, I think you're right, Senator. And, these are not easy decisions. But you know what? There are consequences to bad decisions. There are consequences to evil decisions. And, the voices of the victims who've gone through these is just brutal and devastating. And we need to, there are consequences to bad decisions, and I don't think we can ignore that or just gloss over it.
Thank you.
You're welcome.
Good morning, Mr. Attorney General. I've got a couple questions for you, and because I think we have to recognize some other factors that we as legislators may have to contend with, and you as we move forward on this issue. There are, by my count, at least two federal court decisions in Michigan dealing with the issue of retroactivity. In one case, I believe a federal judge said that Miller should apply retroactively, and in the other case, a federal judge said that the Miller decision effectively renders our parole system unconstitutional, and therefore these cases should be re-examined retroactively. What's your opinion of those two decisions, and what steps are you taking to either appeal or possibly comply with those?
And these are good questions. First, with respect to a federal judge's decision with respect to the retroactive issue in Miller. As I mentioned in my earlier comments, and we have great expertise and knowledge on this Supreme Court process, and it'll be 2 to 3 years until the United States Supreme Court makes a final ruling on as to whether or not the retroactivity issue does indeed apply. There is a current Supreme Court decision, I don't mean to get overly in the weeds, in the case of Teague, that says that decisions of the United States Supreme Court on procedural issues do not apply retroactively. And so the question is, does a hearing, is that a procedural or a substantive issue? These are weighty matters. They'll go through the process. They'll go through the district court, U.S. District Court. It'll go to the Sixth Circuit. It'll go out and be briefed. It'll go to the United States Supreme Court. So it's a 2 to 3 year time frame. But until we get there, until we get there, and depending on what the Supreme Court may or may not do. And this is not a guessing game, and that's not what our system of justice is. It's, playing by the rules, and right now the rule is no retroactivity. Now, there is a Michigan case of People v. Karp that was ruled on by Judge Talbot in the Michigan Court of Appeals, a colleague of Jessica Cooper's and mine when we served on the Michigan Court of Appeals, that says that there is no retroactive application of Miller. And so that's the Michigan law right now. That's pending before the Michigan Supreme Court. And we'll see what decision they might make.
Are you concerned that that at the federal level, say the Federal Department of Justice, do they have the ability to intervene in on a state-by-state basis and effectively mandate retroactivity to the state of Michigan? Is that a possibility?
No, and the fact is that the federal government could intervene as a party and take a side one way or another as the case moves through the federal system. But we have a system of laws where we have the legislature and the executive branch and the judicial branch, and no attorney general, whether a state attorney general or federal attorney general, can have selective enforcement of the laws or the Constitution. She or he cannot say, well, this one I'm going to enforce, this one I'm not, this one I'm going to change, this one I'm not. It doesn't work that way.
What about a third-party lawsuit playing off of some of the recent federal decisions? Is that something that could be used as a vehicle to accelerate the move towards retroactivity?
No, I don't think so. I mean, there may be parties that may wish to intervene or join as a party with respect to the decision that might be made in a federal district court in Michigan or in other part of the country. But I don't think that would accelerate things. It'll be a 2 to 3 year process is my anticipation. And Mr. Birch, the Solicitor General, will, I know, have some comments on that as well, Mr. Chairman.
All righty, thank you.
Welcome.
Mr. AG, we do have several questions from some of our House members here today. I'd like to start with Vice Chair Graves.
Thank you, Mr. Chair. Mr. Attorney General, thank you for being here. Appreciate your leadership on this issue. As you know, I represent portions of Genesee County and Oakland County. You mentioned Flint, so
Yes, you do.
we definitely do not want to be viewed as being light on crime.
No, you see it firsthand,
Yes, sir.
Representative. You do. You understand it.
And I appreciate the governor's stance on the crime we have in the area, and he's stepping up. And I fully support him on that. Mr. Attorney General, I met with individuals from your office. I met with bill writers to try to fully understand this process. And correct me where I'm wrong on this. The Supreme Court has ruled our current sentencing guidelines is unconstitutional. And we need to go back and we need to analyze all 368 cases as far as their involvement in the murder and resentence all of them.
No, that's not true.
Well, when I say resentence, some are going to be evaluated and say, okay, you do not deserve another chance. So get comfortable, you're going to stay there for a while.
It's really the question on the retroactive feature, whether or not that does apply retroactively, Representative Gray. So that's the issue.
Okay, on the retroactivity, if we have been ruled unconstitutional going forward, prospective, why wouldn't it also apply to being retroactive?
And here's the two things, and these are very good questions. First, there's the issue of finality. In our system of justice, there has to be a final point, or whenever the United States Supreme Court would issue a decision, we would then have to relitigate every single case that might come down in the future and how it might have impacted someone in the past. And as Solicitor General Birch will discuss, so there's a case called Teague that says the United States Supreme Court decisions, that's the holding now, do not apply retroactively on procedural issues. Now, they're different on substantive issues. Sometimes it does go backwards. But the point here is we have a finality issue, and then that's the whole point of our system. Good question, but that's how it works to have some finality in legal decisions.
If I may, Mr. Chair.
Thank you, Joe.
Rep. Graves?
We have a 15-year-old to 17-year-old who may have been present when the murder was committed.
Mm-hmm.
A judge at some point looks at that case and say, okay, that person was present, was not the gunman, they may have been the driver, whatever, it may even been a house. They're viewed, okay, we're going to give you a maximum of 60 years. So maybe 30 to 60, 25 to 60, however the bill is final. The ones who actually, committed a heinous crime, they were the ones that pulled the trigger. They're the ones going to be told, you do not qualify the metrics, you do not meet the metrics, you will stay there. Is that the way, am I correct?
But you're really touching on the issue of felony murder. And for 30 years, Michigan courts have been dealing with this issue of felony murder. And you need to understand this point, and I'm sure you do, and let me just reemphasize it. When a crime occurs, a homicide occurs, then what the prosecutor does, she or he, and Jessica Cooper will talk about this, he or she exercises his or her discretion as to whether or not the circumstances and evidence of this crime of felony murder, when someone might have been in the car, and see what the circumstances might be as to whether or not this was just outrageously heinous. And then secondly, if that decision is made to charge, then whether or not the evidence is then presented in front of the jury, and then the jury makes the decision whether there's sufficient evidence to determine that indeed this person is responsible and part of a plan or design that caused a murder. So in 2 points, there's a screening process. First, when the prosecutor chooses to charge or not as an adult, Mr. Kesto, you know that as in your prosecutorial days. And then the question is, what does the jury make in their final deliberations? So that's how there is a decision made whether or not to charge, and then do the facts and circumstances of the case warrant murder one in a felony murder issue.
But if I understand this correctly, a judge will review this and decide which category they fall into.
Well, the prosecutor will make a decision as to charge, and then the judge and jury makes a determination on what are the facts and circumstances of the case and whether or not there's sufficient evidence for conviction.
And if the law is revamped, the parole board will have the final decision. Is that correct?
If the law is revamped, I need to make sure.
To give you a 30 to 60. Doesn't
Well,
mean you're getting out in 30. It means
That's true. But again, for me, the thing I kind of leave the committee with for consideration is that you want to fashion some sort of trigger that should the United States Supreme Court in 2 or 3 years from now rule on retroactivity, that you put in features to cover that, and then have a prospective approach, say 30 to 50 years at a minimum. That's something for all of you to discuss.
Thank you, sir.
Thank you, Joe.
Mr. Chair.
Thank you very much. Minority Vice Chair Oakes.
Thank you, Mr. Chair, and thank you, Attorney General Schuette. I have a couple questions, but first I want to make sure that we're clear, because you keep indicating that the Supreme Court has ruled on juvenile lifers without parole, when in fact I believe their ruling was that they were not going to address that issue at that time. Is that correct?
You're talking about the United States Supreme Court?
I'm talking about Michigan.
Well,
Supreme
the
Court.
Michigan Supreme Court it's been pending. The Michigan Court of Appeals ruled in People versus Karp that Miller is not to be applied retroactively.